All right, so there are, by and large, two types of cases that the courts might actually take on. First is criminal cases, and the second is civil cases. Now, this is pretty straightforward. Now, criminal cases are when somebody commits something that is illegal, obviously, and it's possible that they could lose their freedom, or in extreme cases, they could be put to the death penalty. Now, there's a higher burden of proof involved in criminal cases, the standard being beyond all reasonable doubt, meaning that it is on the burden of the state to present enough evidence that no reasonable person would think that it's possible that there was any other way that the crime could have been committed except that the defendant actually committed it. The other kind of case is civil case. Now, usually civil cases don't involve anybody having actually broken the law, but rather has caused some sort of harm, financial, physical, or otherwise, without actually breaking the law or doing something illegal. Now, the burden of proof in these types of cases is much lower. The legal term is a preponderance of evidence. Somebody just has to prove in a civil case that in order to be civilly liable, they have to show that a person was more likely responsible than not. If it is, think of it this way. In a criminal case, the state has to prove that the defendant is 100% likely to have committed the crime. In a civil case, the parties involved just have to show that it's 51% likely, more likely than not, that the person is responsible. And of course, the penalties are much lower in civil cases, usually involving some sort of financial settlement. Now, there are other types of cases that are sort of offshoots of civil cases. The first is standing. This is when a court determines whether or not that a person actually has a legitimate claim in filing civil suit against a person. So, for example, a famous case that was decided on standing grounds is actually the case against Proposition 8, which was California's same-sex marriage ban. When the state of California refused to defend it after the initial trial phase, various activist groups got together and defended it on the state's behalf. However, when it finally got to the Supreme Court determined that the organizations defending the law did not have the proper standing. They weren't being harmed by it, and consequently, they didn't have any grounds to actually challenge it, didn't have any grounds to actually defend it. And so the case went back to the trial level, and it was ultimately overturned. Now, sometimes cases can involve multiple states and multiple jurisdictions. Now, these are called class action lawsuits. These usually take the form of when citizens from several states are taking on a national company or organization because of some sort of civil liability that caused public harm. Now, let's talk about the hierarchy of courts. Now, first off, let's talk about the state courts. And these are a separate entity from the national courts. Here, and you can pause this and look at it more closely if you want, is the basic structure of the organization of the Texas courts. You have the justice and municipal courts that are the lowest level. Above that are the county level cases. Now, if they were to appeal something at the county level, it would either go into the district courts or into the Court of Appeals, depending on the nature of the case. And then from that, it would go to one of the two high courts. Now, Texas is unique in that it does not have one state Supreme Court. Rather, it has the Texas State Supreme Court, which deals with civil matters. And then there's the Texas Court of Criminal Appeals, which deals exclusively with criminal matters. And Texas, by the way, is also one of the states that elects all of its judges, including those members of the two high courts in partisan elections. So, because of this, there are many debates as to whether or not judges should be elected. Now, the common argument for why they should not be elected, but rather appointed, is because they might consider, rather than the facts of the case regarding a particular defendant, they might think about how the community is going to react to certain decisions in that case. Nobody ever got elected, so they say, for being fair on crime or easy on crime. It's tough on crime. And so there is this concern that just judges and justices might take public opinion or their own political prospects into consideration whenever they are dealing with cases. Now, the argument for elected judges is that they are held accountable in public elections. If the public does not like what they are doing, then they can be voted out. It allows communities to set their own standards with regards to criminal safety and jurisprudence. This is an ongoing debate. Texas, has every once in a while it becomes an issue of whether or not it's going to convert to some sort of merit system or an appointment system or continue with a political election system, but it doesn't look like it's going to change anytime soon. Which incidentally, that is one of the criticisms also, is that anyone can run for judge. You don't have to meet any sort of criteria. And so this is a big reason why the method by which we choose judges is so controversial. There are, just as many ways of going about choosing and selecting judges as there are states. Some elect them in partisan elections, others elect them in nonpartisan elections. Some are appointed by mayors and governors, and others have what are called retention elections, where the governor, for example, will appoint a judge, and then every 2 years or every 4 years, their name will be on a ballot, and the public can vote on whether or not they want to retain that judge on the bench. So going beyond the state courts, I've put here a diagram that shows how the state court hierarchy sort of fits into the federal court hierarchy. A court case can start in many places. It can start in the federal courts, in the district courts, and somewhere in the bottom blue boxes down there, or it can start in local trial courts, in which case it makes its way up through the state courts, such as the Texas state court system that I just showed you. But if it goes beyond the high state court, it can then go on to the U.S. Circuit Court of Appeals, and if they appeal further, they can apply or petition the Supreme Court to be heard, and then the Supreme Court will decide whether or not to grant what's called a writ of certiorari, which means they will agree to actually hear the case. And that process is rather cumbersome. The Supreme Court gets hundreds and hundreds of petitions every single year, and they only hear a handful of those cases, sometimes only going into the double digits. First off, they have to be petitioned. They then goes into the cert pool. In other words, just a pool of all the cases they actually have to consider. Those petitions go into conference where they will be discussed amongst the justices, and they will decide whether or not they want to hear them. Now, it takes a vote of 4 justices on the Supreme Court to determine whether or not they will actually be heard for oral arguments. Once the oral arguments are conducted, justices will go in conference where they will sort of cast their initial vote. That begins the lengthy, months-long process sometimes of opinion writing, and they will write the majority opinion, and if necessary, the dissenting opinion. And a more detailed look at this process is in the book. So in terms of how justices behave, there are 3 models of behavior that people discuss. Now, I'm not going to say that justices follow one of these models or 2 of 3 models or all 3 of these models. Rather, they sort of, these models are used to try and predict how the courts will decide on certain issues. So the legal model is when you try to consider or predict how the court will rule based solely on the facts of the case and the plain meaning of the actual relevant statutes. The attitudinal model looks at basically, how have these justices voted before? Have they voted for progressive outcomes, conservative outcomes, and basing your prediction on that history, how do you think they will vote in the future? Strategic models. Justices, I said, are not partisan. They can be political, however. They can be cognizant of the political environment, and they can sometimes make decisions that are based on what the political environment looks like outside of the judicial branch. So what does this mean in terms of how the justices vote? Well, as of right now, they typically have voting blocks, either conservative, liberal, and there's usually one or two justices who are at the ideological center that can swing the court either way. So for about 20 years, Justice Kennedy was the court's decided swing vote. There were the four justices, Sotomayor, Kagan, Ginsburg, Breyer, that consistently voted with the progressive side of things. Roberts, Scalia, Alito, and Thomas that consistently voted for the conservative outcomes. It is worth noting that in most decisions, Breyer actually noted this himself in an interview a couple of years ago, on most decisions, they are actually unanimous. On a lot of the decisions, it's actually 9-0, but on the really hot button controversial issues, it's often 5-4 decisions. So what does the court look like now? With Roberts now at the ideological center, it was predicted that he would move the court more to the right with Donald Trump's two recent appointees, Gorsuch and Kavanaugh. And it has been predictable in the sense that they do tend to vote in blocks. Sometimes Roberts does vote with the more liberal wing of the court, which he did this week when he voted with Sotomayor, Ginsburg, Kagan, and Breyer to strike down the Trump administration challenge to DACA, which was rather surprising. People thought that he was going to side with the conservative bloc on that. But sometimes the way things break down in the court isn't straight along ideological lines. Take this other court case regarding whether or not the Civil Rights Act could be extended to protect gay and transgender workers. This was decided 6-3 that it did. So Roberts, again, the swing vote, so to speak, the ideological center of the court, sided with the liberal wing, but unexpectedly, Neil Gorsuch, who is one of the more conservative members, also joined the majority in this case, rather unexpectedly. So it just goes to show you that though previous voting records and judicial philosophies and attitudes can normally be predictive of court decisions, the court is still made up of people, and people can be, at times, unpredictable. Now, the court does have its limits, which is unusual given how powerful it is compared to other Supreme Courts in other countries. They have no enforcement mechanism. Rather, they rely on the executive, the legislative, and the state governments to enforce its decisions. It cannot proactively declare decisions on controversial laws or new laws. They have to wait for cases to actually be challenged in the court system. And this goes not only for the Supreme Court, but for all courts at all levels. They can, at their disposal, send strong or weak signals. So, for example, they can overturn a law in its entirety, or they can write a more milquetoast decision in which they declare disapproval, perhaps, of the law, but don't really take any assertive steps to strike it down, or, for that matter, to offer a full-throated defense of a law. And finally, legitimacy. Again, one of the impacts of not having an enforcement mechanism is that they rely on the perceived legitimacy of the courts. The fact that they don't have an enforcement mechanism means that they are relying on the political branches and to some extent the public to actually follow their rulings. And so they have to be seen as a legitimate source of authority in matters of jurisprudence. And so that's it. That's all I've got for the courts. If you have any questions, please, as usual, feel free to email me.